जब जाते हैं ना कि क्यों किया, तो क्यों किया में तो फिर बहुत सारी वजूहत हैं और वो जहाँ तक बताई गई हैं और मेरी ज़ाती राय में एक अच्छी वजूहत दी गई हैं। अब उनकी नीयत क्या थी, नीयत तो कोई नहीं देखता है ना, वो तो ऊपर वालों की नीयतों में आप नहीं जाते हो ना। वो लोगों ने कलमे पढ़े जब उनका गर्दन तलवार के नीचे थी, तो मगर फिर भी उन्हें पढ़ लिया तो बात ख़त्म हो गई थी। तो अब हम उधर नियतें क्यों जा रहे हैं? हम सीधा आईनी बात है, छोटी सी बात है, इसका इतना हमने लंबा इसको खींच रहे हैं, अच्छा है बुरा है, ऐसा है किया वैसा किया है। तो और दूसरी बात है कि आप एक दूसरे को लड़वाएं तो नहीं, आप एक इंस्टीट्यूशन को दूसरे से भी, हम उस इंस्टीट्यूशन की कदर करते हैं और हम चाहते हैं कि वो हमारी कदर करें, और हम जहाँ तक कोशिश करें एक दूसरे, वो हमारे कानून जो बनाए हम उनको सराहें जहाँ तक मुमकिन है, और वो हमारे फैसलों पे अमल करें। इतनी सी बात है।
Entry 55. अब I think अब separation and independence we move on to entry 55.
आगे बढ़ें।
क्वेश्चन पे आगे एड्रेस करें।
You see, as the Honorable Chief Justice said, there is one question. Actually, I had posed two questions. The stages, well, they are the stages of the same question. The first question was, you have to show that the Parliament is competent. So there is a question of competency. But the probe doesn't end there. Even if the Parliament is competent, some provision of the law is in conflict with the Constitution, it can still be struck down. So
I stand corrected. I stand corrected. दो क्वेश्चन थे, ठीक है।
You would not only have to answer the question of competence, you would also have to take us to each provision and justify that it is not in conflict with any provision of the Constitution. So keep that in mind and please proceed.
My Lord, with laws, I thought their constitutionality is assumed. The party shows that this provision is unconstitutional, and then I defend that provision. It seems so that all of the provisions have so far.
You think the burden is on the person challenging it, and the burden does not lie on you to justify it.
Yes, and then if the burden is
But since the question has been
obviously
posed, so you can see.
and I'm assuming from this question,
So you
that
can
at least
answer
in
it.
my Lord's estimation, that burden
I
stands
assume
discharged.
I assume you're not going to rest your case by saying they failed to discharge the burden.
My Lords, now with this question, I actually wanted to move to entry 55, but this question is something I'll come back to. I'll then come back to it because appeal ki baat hogi.
Go at your
My
own
Lord,
pace and according to your own
if my Lords, if I may take your Lordships to entry 55 now, and my reading of entry 55.
अच्छा, पहले ये वजाहत कर दें, क्योंकि एक राय है कि 55 है, दूसरा है 58 है, दूसरा है, तीसरी राय है कि 58 है, मगर 58 ना भी है तो 55 फिर भी है। तो आप कोई, आपका क्या स्टैंड है?
मेरी राय में, as far as section 5 is concerned, it is rooted in entry 55, and the other provisions are to be construed under Article 142A, read with 58, and then back to 191.
So what,
as far as entry 55 is concerned, it may be read with entry 175 clause 2 and entry 55.
What was
read
very
with
aptly put by your predecessor in the line of arguments, Mr. Faisal Siddiqui, that it's a ping-pong effect. It goes from 58 to 191, back to Article
58 is a gateway. I mean, 142, where everything starts, takes you to the list. 58 brings you back to the Constitution. 1 through 57 keep you there. So that is how I see it. I see how the Constitution is functioning. So entry 55, my lords. Now there's two parts, but I read these two parts somewhat differently than how my predecessor had read out. I'd read it first, photo, and then I'd submit how I read it, and then make my submissions. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution. I take a pause here. And the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers. My lord, my reading of entry 55 is that the last two parts, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers, have to be read with the exception, except the Supreme Court. And insofar as jurisdiction and power of all courts are concerned, I'd read it, jurisdiction and power of all courts with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution. So this term, to such extent as is expressly authorized by or under the Constitution, is in relation to all courts except the Supreme Court.
So you're saying the
For the purposes
enlargement of jurisdiction
is for
should
the
not be
Supreme
read
Court.
with expressly authorized by or under the
Yes,
Constitution?
yes.
I didn't get this point. I didn't get this point.
What
Well-
you're saying is, as far as the Supreme Court is concerned, the enlargement can only be done where there is specific authorization.
No, no,
You're
sir.
saying otherwise.
I'm saying otherwise.
You're saying for the Supreme Court, you don't need any express authorization. It is
For the Supreme
assumed.
Court, there can only be enlargement, and we have to go to the language, and there is no such thing as far as
Express authorization की जरूरत नहीं है.
सो सुप्रीम कोर्ट के लिए ये अप्लाई नहीं करेगा, हाई कोर्ट्स के लिए करेगा. वो इसलिए करेगा बिकॉज हाई कोर्ट्स में देर आर not just high courts, all courts, because there are three sorts of courts which are dealt with under the
No,
by the
but you are
Constitution.
saying to
lost me
read
somewhere. I have
jurisdiction
not
and
understood
powers of all courts to such extent as expressly authorized by or under the Constitution.
With respect to any-
Yes, so you're saying read the jurisdiction and powers of all courts with expressly authorized by the
So
Constitution.
let me just
Where is it expressly authorized by the
जी भूमि मैं उस पे
Constitution?
आऊंगा. I would read with respect to any of the matters in this list and this is in conjunction with, to such extent as is expressly authorized by or under the Constitution, and then the comma is separating what is to be done in so far as Supreme Court is
So there's no restriction on enlargement of jurisdiction as you read.
of the Supreme Court.
Then
Yes.
what happens to expressly authorized by, I'm not.
My lord, this in my respectful submission, this is something which
For
relates
other
to the
courts.
high courts, administrative courts, and federal Sharia courts.
Okay,
Why
so
then-
you
why-
mean the
High-
bar is lower for the Supreme Court and
No,
higher
there is a
for
reason.
the other
No, there is a reason. Because
Positive.
as far as jurisdiction and power of all courts are concerned, it can be done through statute, but only to such extent as is expressly authorized by or under the Constitution.
No, but then-
And in relation to the matters
that
in
can
this
be,
list.
because that can be curtailed.
Yes.
But in case of the Supreme Court, its
It can't be
jurisdiction
curtailed,
cannot be
and it can't be curtailed. And
interfered.
if let me just walk you through Article 199 and then 212 and let's just do.
Sir, let me read this entry 55 just to make sure I have understood, because I'm sorry, I'm still having some difficulty here. So as you read it, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters listed in this court
And
to such extent as is expressly authorized by or under the
yes.
Constitution.
So the and used after
And
used
and the
No, there is no
enlargement, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon on supplemental powers. That you say is separate from this.
So as Justice Attar just pointed out, you're saying that it actually turns on the word enlargement because there's a specific thing that the power could be given, that is enlargement, so we don't need to worry about any extent or anything because it's merely
So Supreme
restoring,
Court's-
enlarging, it's not reducing,
your-
it's not altering, it's enlarging. So that's as simple as that.
So
It
as
doesn't have the,
Your reading eliminates the word and surely
and from.
from the text.
So there are two ands here. One is
So
after
first
the
one-
list,
No, the first one.
the and, yes.
Jurisdiction and, sorry, the first one is jurisdiction and powers of all courts
With
except
respect to any
Supreme
of the
Court,
matters in the list
with any
and,
of the matters of the list,
and,
नहीं, अगर आप अब आगे जो चीज आ रही है उसको पीछे से जोड़ रहे हैं, तो ये and तो फिर eliminate हो गया ना,
and के साथ वो conjunctive हो रहा है ना सर?
and नहीं.
In conjunction हो रहा है ना? And to such extent as is
And
expressly
is
authorized
and
by
के
under the
बाद
Constitution.
and
it makes it disjunctive.
and की तो जरूरत ही नहीं रहती ना.
My lord,
अगर इस ना पढ़े, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list to such extent as is expressly authorized by or under the Constitution. Is there any grammatical problem with this? Is there any grammatical problem?
No, it would have
No.
been fine, yes.
So therefore, on your reading, and is eliminated.
No,
And becomes redundant. And makes sense only if it creates the break and then relates such extent as expressly authorized by the Constitution to what is following. आप समझ रहे हैं ना?
what is following
अरे
after
मतलब
and?
अगर आप and की जरूरत नहीं रहती ना आपकी रीडिंग पे.
No, and की जरूरत देखें. अब यहाँ पे
दोबारा पढ़ता हूँ, चलिए दोबारा पढ़ते हैं.
on that count, my lord, and जो है उसके बाद
दोबारा
second
पढ़ते हैं ना, दोबारा
Learned
पढ़ते
Attorney
हैं.
General, Learned
क्योंकि
Attorney
by
General,
और अंडर के
ये
ऊपर
मैं इसकी आपको कॉन्स्टिट्यूशन में भी लेके जाऊंगा to make sense of it.
jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters listed in this, any of the matters in this list, to such extent as is expressly authorized by or under the Constitution. Full stop. Is there any error, any grammatical error in this sentence?
No, it could be read as
Therefore, and becomes
and that is
Why? मैंने full stop भी डाल दिया, just to clarify.
there is a reason. There is a reason. अब मैं इसको
and किधर गया?
इसको जरा करेंगे ना समझेंगे इस तरह से कि there are two jurisdiction जो courts पे grant हो रही है. One is with respect to the matters in the list, and one we have to go to the Constitution, what the Constitution, the body of the Constitution is doing. And for that, if my lord may kindly turn to Article 212, for example. Let's go to 212, let's go to 199. Let's go to 199 first and then see what is the authorization, the extent of authorization as far as high courts is concerned.
उसमें तो जरूरत ही नहीं ना रहती.
नहीं है जरूरत है.
क्या जरूरत?
Clause 5 देखेंगे उसमें. Clause 5 of Article 195, 199,
ये-
which
ये
says
आप क्या-
the
आप-
extent to which Article 199 applies. And there is carve out.
Mr.
The
Attorney
definition
General, I
of-
mean, before, I mean, looking at 55, I mean, we might lose ourselves in the grammar of it, but larger than that is perhaps the word enlargement.
Yes.
And what is actually happening? You're enlarging the jurisdiction of the Supreme Court. It requires no extent because it is a positive thing that you're just adding to the Supreme Court's jurisdiction. So वो उसके साथ पढ़ना मतलब उसके कोई जरूरत
मेरी
नहीं।
रिस्पेक्टफुल सबमिशन है कि नहीं पढ़ना होगा बिकॉज वो फिर काउंटर इंट्यूटिव है. वो इसलिए भी काउंटर इंट्यूटिव है कि देयर इज नथिंग इन 184, 185, 185 में क्लॉज 2D है which says that through an act of parliament आप उसको ऊपर ले जाएं उस अमाउंट को या रिव्यू के अंदर.
इसको आप इस तरह दोबारा मैं
तो इसलिए there is nothing जो प्रोवाइड कर रहा है कि एक्सटेंड क्या है. whereas in the case of high courts for example there is an extent which is provided. For the administrative tribunals also there is an extent which is
Jurisdiction and
provided.
powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution. Full stop. आप इस तरह पढ़ रहे हैं उसको?
मैं इसको जी हाँ.
इसमें
Constitution के बाद comma लगा हुआ है ना,
surely on this,
enlargement.
on this, grammatically speaking for myself, there is an expectation कि इसके बाद भी कुछ आएगा. अगर and हो ना, तो उसके बाद एक expectation है and to such extent as is expressly authorized by or under the Constitution.
Yes.
Full stop creates a vacuum because there is an expectation to such extent as is expressly authorized by or under the Constitution. What?
Yes. So you
लेकिन तो आपका एंड जो है ना,
इसको एक सेकंड के लिए इसको
बात तो
read
समझ-
differently.
Learned
अब मैं
Attorney
आपकी बात
General,
समझने की कोशिश कर रहा
मैं आपको समझाने की
Learned Attorney
हूँ. एंड में ये
General,
प्रॉब्लम है. अगर एंड इस तरह आप से रखते हैं ना, एंड निकाल दें तो कोई प्रॉब्लम नहीं है.
इसको जरा इस तरह से पढ़े. एंड की निकालने की जरूरत एंड क्यों जरूरत है एंड को रखना. So let's just read it again. Jurisdiction and power of all courts with respect to any of the matters in this list. Let's take a pause here. All courts, matters in the list. And then, and to such extent as is expressly authorized by or under the Constitution. Full stop. So my submission is that this language and the express authorization is necessary because 199 applies the constitutional jurisdiction of high courts in terms of territory, of course, but then there is a carve out, the persons to whom this jurisdiction can be applied. And then 212, Article 212, with respect
Do we
to
need
administrative courts.
a professor? Do we need to make amicus a professor of the English language, Mr. Attorney General?
My lord, I
think we can understand it, whatever we understand it to mean. And can I just ask you a related question? Does the Supreme Court have power to enlarge its own jurisdiction? Yes or no?
No.
You are saying the Parliament, their side is Parliament cannot can only do so through constitutional amendment. Now, I don't know why you are skirting the issue.
The Supreme Court is required to or is bound to act in accordance with the.
It cannot enlarge its jurisdiction, correct?
Yes.
How has the Supreme Court enlarged its jurisdiction in cases decided by 3-member benches, by adding on benches, and which jurisdiction was assumed then? There have been recent examples of the Supreme Court creating, not just enlarging jurisdiction, but creating jurisdiction not envisaged in the Constitution. But those are sensitive matters, so you won't talk about them. Correct?
I want to talk something about it. I know, I want to talk something about it. Yeah. And let me just talk about it. And
before you field another question. You can't field 5 questions simultaneously. You have to finish one.
I have to field this question and then I'll come back.
Why did they use the word expressly? अगर expressly नहीं भी होता, by और under का यानी इसका मतलब हुआ कि by के लिए भी express होना चाहिए. देखिए by in itself is always express.
वो मेरा इसलिए there are two. Yeah. One is where the Constitution now, when the term by is used, the enactment in this case, the Constitution directly provides for what can and cannot be done. And under is where an additional act is required in an act of
मैं आपसे एक सवाल इससे आगे जा रहा हूँ. मैं ये कह रहा हूँ.
In support of the people of Jammu and Kashmir in realizing their inalienable right to self-determination. Ambassador Al-Dubey is no stranger to Pakistan and Azad Jammu and Kashmir. This is his 4th visit in Pakistan. He last visited Pakistan in December 2022 when he accompanied the OIC Secretary General. During the current visit, our dear guest will be meeting the leadership of Pakistan and AJK. He will also travel to the LOC where he will receive briefing on the on-ground situation. He would also interact with the Kashmiri representatives to gain better understanding of their plight. As OIC's Special Envoy on Jammu and Kashmir, Ambassador Al-Dubey is tasked with a significant mission. He serves as our vital bridge with the OIC's General Secretariat. OIC mechanisms like Independent Permanent Human Rights Commission, IPHRC, and Islamic Development Bank, OIC Contact Group on Jammu and Kashmir, broader membership of the OIC, and other regional international organizations and the international community. I profoundly thank Ambassador Al-Dubey and his team for successfully highlighting the legal, political, human rights and humanitarian aspects of India's illegal occupation of Jammu and Kashmir, which has further aggravated since India's illegal and unilateral actions of 5th August 2019.
نحن نرحب على سعادة الأمين العام المساعد لمنظمة التعاون الإسلامي والمبعوث الخاص لشؤون كشمير في مكتب الوزارة الخارجية في باكستان، وهذه زيارة الرابعة حسب قوله، وأول كان في السنة الماضية، ولا شك يعني هذه زيارة طبعا هو اللقاء مع القيادة الباكستانية والقيادة الكشميرية، ولا شك هناك خطة لمنظمة التعاون الإسلامي في ضوء كشمير، ولها جهود كثيرة في مجال حول الناس الشعب الكشميري، وخاصة جهودهم وأيضا أمور كثيرة تتعلق بالكشميريين.
The current Indian leadership is bent upon perpetuating India's occupation of Jammu and Kashmir. The Indian authorities are brutally